I have even more good news about the nationwide injunction SCOTUS ruling, and it has to do with another ruling from last year that we also thought was pretty devastating at the time. If you haven't seen any of my videos on the SCOTUS decision and the APA carve-out, I highly recommend you watch them, or at least one of them. I explain it to varying degrees of simplicity. Long story short, while SCOTUS said that a district court judge cannot issue a nationwide preliminary injunction against the executive branch unless there is a law that provides for them to do so, there is a law on the books that grants district court judges a lot of power over the actions of agencies. And the federal agencies are basically any department that carries out the will of the executive branch. And my theory is that the justices provided a very clear carve-out due to the APA, including the ability to issue preliminary injunctions against any acting agency. When the president signs an executive order, you have to understand it's just words. They can put anything they want into an executive order. They can say the sky is purple, and essentially it's a form of like official free speech. Executive order saying that the sky is purple isn't actually a problem until one of the agencies, let's say the FBI, decides to enforce it and punishes you for saying that the sky is blue. Then it's a violation of your First Amendment right. And the SCOTUS case last year that dealt with this was Loper Bright Enterprises v. Raimondo, or the overturning of the Chevron deference doctrine. I did mention this in at least one of my videos. So the Chevron deference doctrine was in place since the 80s. And essentially what it said was, when there's a question about the legality of what an agency is doing, the courts should defer to the experts on their interpretation or understanding of the law. So basically, if the EPA was regulating something and there was a law that said that it could or couldn't regulate certain things, but it wasn't exactly clear what it meant by that, courts were supposed to defer to the experts at the EPA and just kind of like trust their interpretation. But SCOTUS ruled that no, interpretation of the law is strictly in the hands of the courts. And at the time, this felt kind of devastating because it was like, okay, so a judge who doesn't understand the science can just decide how the law applies based on what they prefer, which sounds bad and in many cases could be. However, the DHS is also a federal agency, as is the FBI. And in the Raimondo opinion, SCOTUS specifically says, Congress in 1946 enacted the APA as a check upon administrators whose zeal might otherwise have carried them to excesses not contemplated in legislation creating their offices. It goes on to say, it makes clear that agency interpretations of statutes, laws, like agency interpretations of the Constitution, are not entitled to deference. So essentially, they made it a lot harder for a federal agency to make the case that their interpretation of the law or Constitution was coming from a position of expertise. Judges used to have to kind of defer to this. To what extent they did in each case obviously depends. And considering the courts are not supposed to defer to any sort of expertise in the agencies, if they're arguing based on their expertise that a nationwide injunction would be terribly harmful, a judge shouldn't take that into consideration very much at all. I think we're good.